Hi there and welcome to In Your Corner. I'm John Scholes, Sivan Tamarkin, and back by popular demand, James Fireman is back with us today. Good to see you, pal. How are you?
Good to see you too, my friend.
Before we get started, a lot of stuff to cover on the show today. To reach out, help at inyourcorner.ca or inyourcorner.ca is the website, and 1-833 In Your Corner, that is the phone number anytime. We'll put it up on the screen throughout the show. In case you didn't write it down as I just mentioned it. Guys, busy show today, but first, James, it's good to sometimes go over just to reiterate what this show is all about, right?
Sure. So I think the biggest issue that I see with people who have been denied their LTD benefits in particular is a lack of information, a lack of understanding about the process, what their rights are, what they can do, and more importantly, what the insurance company can do and can't do. And so this is really an effort to speak to those people directly and let them know, give them the information so that the power imbalance that is normally there is leveled off. The playing field becomes that much more even. Right. And the people who are watching, if you're denied your LTD benefits, you're going to know what to do. You're going to have a much better understanding of the process right from the start. That's the purpose. That's why we're here.
You know, it's funny, and we talk about it all the time. You can go and look at billboards when you're on the highway, and it's, you know, listen to a quick commercial, which is good, which is great. But until you get really into the meat of what this business is all about, you've got to have understanding. You've got to be armed with the right information, which is why we do this show as well. A lot of stuff to get through, but what we'd like to do, I know, Sivan, is you talk to so many people, you deal with so many cases, so many wonderful stories about what comes out the other end when you're finished with those cases. A success story, basically. You have one for us this week.
Well, I can tell you that I have a case to tell you about, and it hasn't come to conclusion yet, but I want to tell you why it's a success story. It's a lady who had called me last week on behalf of her husband, and we get that a lot, by the way, spouses or siblings, friends, people who call on behalf of other people who want to get information and get us to help their friends and family members. And so this lady called me up. Her husband is 53 years old. He's been a mechanic for just over 20 years, and he's developed back issues, sciatica issues, knee issues, and he has a lot of difficulty standing and even sitting down. And so he's been on long-term disability for over a year, and he was just cut off last week. And that's the reason why she called me, because she wanted to know, does it make sense to challenge the insurance company to start a legal claim? Now, here's the interesting thing. She's the one who called me, not her husband. And here's the reason why. Because the adjuster that he has been dealing with has been very difficult to deal with. That adjuster has been a bully. And she's been trying to tell him, you're not disabled, we don't believe your doctors. I mean, she didn't say that, but she essentially insinuated that. And eventually that culminated in a cutoff of his disability payments, and he was the primary bread earner. And when I told her what we can do for them, and that this, based on the medical documentation, is not that difficult of a claim to resolve, you know what was the highlight of the conversation? It wasn't that we can actually get the insurance company to pay him what he's owed. It was the fact that we're going to be speaking with that adjuster going forward. We're going to deal with the insurance company. He's not going to have to deal with them. The letters stop, the emails stop, the phone calls stop. And that's what happens in every case when we get involved. We stand between the insurance company and the individual. No longer is there any communication between the adjuster and the disabled person.
Isn't it kind of the case where it's not really that the person who's being cut off is not being taken seriously by the insurance company, but once you guys get involved, now they got to step up. Now they have to take it seriously, right?
They do. They do. I mean, they understand at that point that they're dealing with no longer the disabled person who is in a precarious state, right? Is in a very weak state. That they're dealing with their disability, and their family members are dealing with a lack of income at home. Now they're dealing with us. We have experience. We've worked on the other side. We've worked for insurance companies. Sure. We understand what the pressure points are. It's a completely new game. And as James said it, you know, we leveled the playing field. And in fact, you know, as James put it out before, we actually tilt it in your favor.
Sure.
We actually take the fight to the insurance company and get them to pay you what you're owed.
It is help at inyourcorner.ca, and 1-833 In Your Corner is the phone number. Your partner, Lior, as you know, we all know now, the Employment Hour radio show. Quite often you're on that show because there's a lot of crossover between disability and the employment world. We get a lot of phone calls on that show, and a lot of them are directed right at you as far as disability is concerned. I want to get to a phone call and have you comment on this event.
Absolutely.
If a person is eligible for long-term disability, why are they saying that it is also mandatory that they apply for CPP disability as well. It just seems like you have to jump through the insurance company's hoops. Now you're going to have to go through CPP as well. And when a person is ill, they really, having to go through all these things and mega packages of this has to be filled out and that has to be filled out. Once you've applied to the insurance company, why is the insurance company demanding that you have to apply for CPP as well?
Yeah, it's good. We get that question through email all the time as well. What do you think?
Well, listen, most policies, they're trying to make you jump through hoops. That's not an accident. So one of the things I think people need to understand is what CPP disability is, because it's just not something that everybody understands. So if you are working and you're paying into CPP and you are injured, you may be entitled to get CPP disability benefits. It's not the same test as what you need to apply for if you're applying for LTD, but it's somewhat similar. And so that's something that is available to you regardless of any other insurance that you have, as long as you've been paying into CPP disability. And so most insurance policies, most LTD policies have language in the policy that says if you are claiming and you have the ability to apply for CPP disability, you have to do it. And if you don't, they're entitled to take a credit for what you might get if you were approved.
Might, so it's an assumption.
Right. So if you do apply and you're denied by CPP, then you're still entitled to the full benefit.
Okay.
But if you don't apply and the insurance company says, oh, you never applied, we're just going to take the credit for that. So that's why they're doing it. It's something that's written into the policy that they are entitled to. And so they're trying to enforce that. The fact that it makes it more difficult for you from their perspective is an added bonus, because really, that's what they want. They want it to be a difficult process for you. They don't want to make things easy. They want to do whatever they can to reduce the benefits. And so if at the outset it looks like this is going to be harder for you, or if it's going to save them money, that's a bonus for the insurance company. That's why they're doing it.
I know we've often talked in the show about when you apply for CPP disability, not necessarily, but can it be a higher threshold to qualify for CPP, thereby making it better for your own insurer if you pass CPP?
Yeah, the test for CPP disability, the language that they use is a severe and prolonged disability.
Right.
And in my view, and in the view of most people that practice in this area, the test for CPP disability is a tougher test to meet. Okay. And so if you apply for CPP disability and you meet that test, in my view, there's very few circumstances where you wouldn't also meet the test for a standard LTD policy. It's not impossible, but in most cases you would. And so, that is certainly an argument in your favor if you've been approved for CPP disability. Right. But if you're denied, I don't think the reverse holds true. I don't think the insurance company can or should turn around and say, oh, well, you didn't get CPP disability, therefore you don't get this. It's a tougher test.
But that happens. And that's very key for people to understand, that if you're denied CPP disability and your insurance company turns around and says, because you were denied CPP disability, we are therefore denying your LTD claim or cutting you off, that's a big no-no.
Right.
There's no reason whatsoever why the insurance company would say that. And oftentimes, well, that's not true. They do say that because they assume that you're going to buy into it and you're going to walk away. You're going to think to yourself, okay, well, everyone's denying me, therefore I don't qualify. It's not that simple, which is why you should be contacting us and we can talk you through it and look at everything and then tell you if, in fact, the insurance company did the right thing by cutting you off, which in most instances, when we speak with people, we end up concluding that no, they have not acted properly in cutting the person off. Guys, lots more to get through. We're going to take a short break, though. Coming up here, we'll get to the 3 mistakes adjusters sometimes make on LTD claims. That is just ahead, so stick around. 1-833 in your corner and inyourcorner.ca for the website. Don't go anywhere. We'll be right back.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner. It is inyourcorner.ca and 1833 In Your Corner. Guys, love these. We do these every week. These are very important. It's usually like a top 3 or top 5 list. And this week it is the top 3 mistakes adjusters sometimes make on LTD claims that you should know about. This is all very important stuff. That's why we do this show every week. I'm just going to start with the first one, guys, and I don't know who's going to handle it. Maybe both of you. First one, the adjusters, again, they make decisions on denial or approval of claims without reading all the medical documents you give them. And I know you have a story about that as well, right?
Can you imagine, John?
Yeah.
An adjuster tells you you're no longer eligible for LTD, and then you find out later through your lawyers, that in fact they haven't reviewed everything. Yeah. The story that I was going to tell you is about an associate at our office, Albert Klein, who had discovered, that's the terminology, it's like doing a deposition in American terminology, of an LTD adjuster, an adjuster that had cut one of our clients off. And he asks the adjuster straight out, under oath, did you review all of the medical documentation before making the decision to cut the person off?
Yes, I did.
Yes, I did. Absolutely. Unequivocal. So he starts taking her through the medical documentation, some of which included handwritten records from some of the treating physicians, the doctors.
You know how that looks.
You know exactly how doctors' handwritten records look. Yeah. And of course, you can't decipher them. They're like hieroglyphs. And one by one, she's admitting under oath that she hasn't read this one, and she hasn't read this one, and she hasn't read this one. You just imagine what that makes them look like, her and the insurance company. And I can tell you that that insurance company, that adjuster, and the lawyer defending them is that much more willing now to come to the table and settle the claim. And that's what people need to understand, that when these adjusters tell you, we've reviewed everything, don't assume that is correct, don't assume that is true.
Why would they go in unarmed?
Well, listen, it's not always that. You might assume that they're just being lazy. And perhaps that's true sometimes. I don't make that assumption. I've done this long enough to understand that the adjusters are generally overworked. They've got too many files, and the documents for any one file can easily go over 1,000 pages, 2,000 pages. It's a lot to go through, and to go through it meaningfully, to really understand what's in the file, takes an awful lot of effort, and frankly, I don't think they always have the time to do it. I had a case recently that I wound up settling. I found something in the file that made the claim worth less than it ought to have been. I thought it was going to be worth more, but my client was doing better, at least according to the most recent notes.
Right.
That was in the file. The insurer had it. This was after we brought the claim, but they had this information and clearly hadn't read it when it came time to mediate, because frankly, they paid a lot more than they ought to have in the circumstances, but so be it. If they're not going to read the file, if they're not going to take the time to go through it carefully, then it's to our benefit, and we use that against them.
Again, if you're just joining us, we are doing the top 3 mistakes adjusters sometimes make when dealing with LTD claims. You got to know about these. Number 2, they make decisions based on the wrong consultants.
Yeah, this happens all the time. I mean, in a perfect world, you would have well-trained adjusters that had enough time to go through all the files, and they would refer each file to an appropriate medical expert that specializes in the area where the claimant has a disability to do an independent assessment. That's in a perfect world. We don't live in a perfect world. You almost never see that happening. What you typically see happening is the insurance company will give the file to someone who works for them that specializes in a somewhat related field, perhaps a kinesiologist, a vocational specialist, something like that, very rarely a doctor, and they'll give their opinion, and then the insurance company is just going to take that opinion and ride with it. Sometimes they will hire a doctor. Typically, it's someone that gets a lot or all of their business from either that insurance company or from a couple insurance companies. And usually they have 2 doctors that they're choosing between. A family doctor, so it's someone who can comment generally on physical medicine, and a psychiatrist, someone who can comment on mental health claims. And they don't really go beyond that in terms of specializing. Occasionally, for more serious claims, they will send it to an appropriate doctor, but usually not. And the reason is simply it costs them too much money to do it.
Right.
They want to keep as much of your money as they can, and so they do that by cutting corners. Simple as that.
Would you then jump on that case? I mean, nothing against kinesiology. It's a wonderful vocation. But if you see that, you go, okay, that's not really an MD. Will you get on that? You jump on that?
Sure, and I agree with you. I'm not trying to beat up on kinesiologists at all. And in the process, their opinion can be quite valuable.
Right.
But if this case goes to trial and a judge is taking a look at the opinion of a specialist doctor that is well qualified in a particular area of the disability and weighing that against a non-treating kinesiologist who has done a paper review of the file for an hour, who are they going to believe?
Yeah.
I don't have to beat the insurance company over the head with it. They know what's coming.
One more here. Top 3 mistakes adjusters sometimes make on LTD claims you got to know about, and this one is probably huge in your business. That is, they've misread or misunderstood your LTD policy, right?
Yeah, I mean, you would think that how can this happen? I mean, it's their policy, right?
Right.
How is it they can misinterpret a term? But, that case that I told you about with our associate Albert, who had got the adjuster under oath to say that that she's reviewed all the documents, and then he showed her that she hasn't. She also admitted under oath that she was never instructed or taught or mentored on what does the term total disability mean. And remember, when they deny your claim on the basis that you don't meet the test for total disability, they have to understand what that
If you know
means.
the definition.
It's pretty, yeah, it's kind of
fundamental.
It's exactly what it is. So imagine when an adjuster says under oath, oh, actually, with my limited education, because many of them, they're not doctors. In fact, I haven't met an adjuster that's a doctor or a lawyer.
Right.
They don't know. And so, if their training hasn't been sufficient, has been lacking, and they make decisions on the basis of what they deem to be common sense, but not the law, well, then that's, open grounds for us. I mean, we can just go in and have a field day with them. And so we see that happen in different contexts. And again, understand that these insurance adjusters, as James put it, they're overworked. I know a lot of adjusters from my time having worked for insurance companies. They're generally good people, but they have a job to do. And their job primarily is to protect their client, which is their employer, which is the insurance company. And they don't often get the training they need to actually execute their job in the proper manner. And that allows us then to, again, take the fight to them and make sure that the insurance company pays our clients what they are owed.
You want to reach out anytime, help@inyourcorner.ca is a good way to do so. That is the email address. We'll get to one from Alfred. Alfred writes in, he says, if you appeal repeatedly and get denied on all your appeals, does that make your legal case against the insurer weaker than you had if you didn't appeal at all?
No, it really has no impact on the strength of your case.
Right.
It certainly has an impact on when your case is going to resolve. The more time you spend trying to appeal, and we talk about this a lot, appealing a denial is a waste of time. You're allowing the insurance company to maintain complete control over the process for no reason. You start a legal claim, you take the control away from them. So if you want to appeal, go ahead. But you're not weakening your claim, but all you're doing is delaying the resolution.
And that clock is ticking, that 2-year clock, right?
Yes, there's a 2-year limitation period that does not get reset with an appeal. Now, the opposite I've sometimes seen argued by insurance companies. And what I mean by that is sometimes I will see an insurance company say, oh, you never appealed. Therefore, your case isn't as strong. Obviously, if you thought your claim was so strong, you would have appealed, which makes me laugh when I see it. It's usually a lack of understanding about disability claims in general, sometimes by lawyers that don't practice in disability law all the time. It makes no sense to appeal, and anybody working in this field understands that. To me, it's sort of like, a bully saying to the principal, oh, I would have stopped picking on him if he had, just asked me to stop, right? It doesn't make any sense, right? Why would you allow the insurance company to maintain control? You take it out of their hands.
But John, I just want to add something. I'm not blaming people for trying to appeal. In fact, if you were to Google long-term disability and go on all these other websites for many lawyers, oftentimes they will not only tell you to appeal, they'll give you tips on how to appeal.
And charge you money for it.
Charge you money for it.
And charge you money for it, absolutely. And then again, who loses throughout this process? You lose throughout this process because not only are you delaying resolution of the claim, but now because you've been without income for all this time, now you're squeezed Now, if in fact we do come into the picture and get the insurance company to offer you money, because you've been without money all this time, now you got the screws to you, right? So you feel like you have to settle, and we don't want you to be in that position. And we understand that, without any money coming in, you got a mortgage to pay, you got potentially kids, there's a lot of expenses. You have to move on whatever the strategy is that's going to make resolution come faster. Right. That's what we employ. And we employ it strategically, but never once have I told a client, appeal a decision. Yeah. As James put it, as soon as you appeal, you are playing within their sandbox. You are subject to their rules. They control you. As soon as you take that away, you start a legal claim, they no longer have control over the process. Now they have to meet us, on the battlefield, so to speak. Right. And we battle it out, and they come to the table and they'll settle. They'll settle, because if they don't settle, they're going to continue bleeding money in trying to defend the claim. Eventually, if it goes before a judge, they have no control over that. And they don't want to be in that position, and they know that. They just don't want you to know that.
What to do when that insurance company requests an assessment. We will get to that, so stick around. 1-833 In Your Corner, and help at inyourcorner.ca as well. Lots more In Your Corner is just ahead. We'll be right back.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833 In Your Corner, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner. InYourCorner.ca is the website anytime to check it out. Another resource for you is called MyDisabilityQuestions.com. That is the place where you can ask your questions. If something has piqued your interest on this show or other shows, you can ask it there. Chances are a very high probability that has been answered in depth. If not, leave it there. Savan, James, one of the team will get to that question and give you some answers. Indeed, we'll get to one. Again, MyDisabilityQuestions.com is the website. LTD insurers sometimes ask disabled persons to undergo an assessment to determine what other jobs they can do. Does a disabled person have to do one of the jobs identified in that assessment, and what rights does that disabled person have? Kind of three pieces to that one.
Yeah, so let's start with why is it that insurance companies ask you to do this assessment? Right. Usually, typically, we see this happen around and close to the 2-year mark. Because remember, within the first 2 years, the test for LTD is, can you do your own job, your own occupation? It's called the own occupation test. Beyond the 2 years, to qualify beyond 2 years for LTD, you have to meet the any occupation test. Can you do any occupation, any job for which you are suited for by training, education, or experience? Okay. And many insurance companies forget to tell you that last part. That's very, very important. You're not going to ask a surgeon who now can't do surgery to go and work at Starbucks. Nothing wrong with working at Starbucks, but it's not really equivalent.
It's not commensurate. That's the test.
It's not, absolutely, but insurance companies don't want you to know that. And so what they'll do is they'll send you to an expert, a consultant, someone who is going to do some testing and, crank out a list of jobs that they think you can do. And I've seen situations where I've had individuals who are 60 years old who all their lives have worked in let's say a factory, a certain type of a job that has a limited skill set, as an example. And they've been told, by the way, you can go and do programming, and you can go and do a whole bunch of other things which I can't do. I don't know about you, but I can't do. Not that I can do much, but the issue is that insurance companies will give you that list, and they will tell you you should try to do one of these jobs, and you can't. Your doctors are saying that you can't. And it's concerning because you feel like if you don't try, then they're going to cut you off. If you feel that you can't, that you don't have the education for the jobs that they're recommending, if you don't have the experience, you don't have what it takes to do those, and your doctors agree with you, and they put that in writing, then no, you absolutely do not have to take one of those jobs. That said, you do have an obligation to mitigate. So to the extent that you can, in fact, do something, one of those jobs, you should try. But only if you can, and only if it is something for which you are trained or have education for or have some experience in.
So in the end, it all leads back to your medical professional.
Sure, absolutely. If your
Right.
doctor says you can't work, then you can't work, full stop. If you feel like you can go back to work, then by all means do. You're in a better position if you go back to work, whatever you're doing, but you're not limited to what they come up with. I had a case very recently that illustrates this point very well. So what happened here, I had a client who had a back injury and a knee injury and really wasn't able to sit for more than 20 minutes without having to stand up for 10 or 15 minutes. Up, down, all day. That's what his life was like. There's no job he's going to be able to get that's going to allow him to rotate like that. And this was someone who had a limited education, so it isn't as though most sedentary jobs would be available to him to begin with. And what happened, the insurance company generates what's called a transferable skills analysis.
Wow.
It sounds very official.
Oh, yeah.
Okay, and the result of this was they found 4 jobs that he was able to do. Of course he could do. And what I did is I looked through the file and I saw how I reverse engineered what the process was. And what they did, essentially, they knew, it was all over the file, that this guy could not sit for more than 20 minutes. The claims handler knew it. It was all over the medical file. You couldn't miss it. So typically, when they have a transferable skills analysis, they're going to send the claimant to an occupational therapist, and they're going to test their functional abilities, see how long you can sit for, see how long you can stand for, what you can lift, et cetera, et cetera. Did they do that in this case?
No, sir.
No, they didn't send him to a doctor. They didn't have a doctor even review the file. They didn't send him to an occupational therapist. And the reason's pretty obvious. They knew what the answer was going to be. They knew if they sent him to be tested, it was going to come back that this guy wasn't able to sit for more than 20 minutes. And there's no specialist that's going to tell them that there's a job available to you if you can't sit for more than 20 minutes. So they just skipped that part of the process and said, you're okay to do sedentary work. And they found that he could do these 4 jobs. It was nonsense. It was absolute nonsense, and they knew it.
Got a couple minutes left, guys. I think we can squeeze in a quick email. Again, it is help@inyourcorner.ca. Kara says, my sister worked as an accountant for over 10 years, had a bad accident a year ago, still getting LTD. She was just let go from her job. Does that mean she will stop getting her LTD?
No, it does not mean that at all. In fact, if your disability arose during the time you had coverage, so while you were employed, if the benefits plan is through your employer, then so long as you qualified for that, or you would qualify for that, it has nothing to do with whether or not you have your job, if you've lost your job. But it's important still for you to speak with us, because if you lost your job, then you're going to be entitled to severance. And not only severance, but if you've been let go while you're disabled, you potentially have an entitlement to human rights damages, because you're not allowed to fire someone while they're on disability. And why that's important is because if you receive severance from your employer, the vast majority of LTD policies contain a provision that states that the insurance company is entitled to a credit for that. So if you were let go from your job, John, and you got $10,000 as severance, the insurance company may say to you, hold on for a second, that $10,000 you're getting, we're actually going to pay you $10,000 less now in LTD, but if you actually get human rights damages, they can't touch that. So, again, very important, and this is, Lior talks about a lot in terms of, severance and termination entitlements, but, they overlap, LTD and severance. And I want to mention something else. Some people don't necessarily realize that they are disabled by the time that they're let go. Let's say you had an accident. There's been cases like that. In fact, a recent one recently, where you've been injured, severe injury, your performance has decreased over time, you've been let go, and at that point, you think to yourself, can I, make a claim for LTD? You can still make a claim for LTD if your disability arose while you were employed.
Lots of stuff on the show today. Reach out if you have any questions, or reach out regardless and just talk to the guys. At least get your bearings in that regard. It is 1-833 In Your Corner. Email us help@inyourcorner, and the website just as simple, inyourcorner.ca. Till next time, we'll catch you next time right here on In Your Corner.